Welcome back, viewers. We've been talking about injuries sustained in the work in the meat industry, and in particular the case of Kelso, Tony, which was heard in the Court of Appeal of the Supreme Court.
John, in Kelso, the Court of Appeal did not accept his appeal. They've knocked him out. They've said that his injury to the thumb wasn't serious. And Kathy, the thing about the Court of Appeal these days is that there was a case of Dwyer which went to the High Court. And in the High Court, the decision was that the Court of Appeal's got to make up its own mind about whether an injury is serious or not.
They need to consider the circumstances of the case, in particular to the worker as at the time of the hearing.
John, can they take evidence? I mean, I thought reading the judgment in Dwyer that the High Court did say that they can take further evidence and consider other material outside the original hearing.
Well, under the Accident Compensation Act, and in particular the appeal provisions, Tony, I think we recall that, yes, the court in itself can take any evidence itself deems fit in regards to this issue. But
the thing is, it becomes a very expensive and very, very long-winded process. Importantly, in that case of Dwyer, what the High Court essentially said, Kathy, was that instead of sending it back, remitting it back to the county court to be reheard, the Court of Appeal has to make their own decision. That's a good decision because it means that you're not bouncing up and down all the time.
That's correct.
You know what I mean?
And we've also got the problems of practicalities, as in trying to find evidence and material and documentation from an event that occurred 5-10 years ago.
And you did have a bit of a nonsense going on occasionally where you'd have a matter to go to Court of Appeal, plaintiff would succeed to get a matter retried, goes downstairs again to a county court judge and loses, and then goes back on appeal again. That could happen. So the good thing about this is that we get a case decided once and for all, and save a bit of expense and time for the courts. There's another case I want to take us to. It's a Q Fever case. It's a case of Tinworth and VW Management and Norvik Food Processing. This case that we're discussing is about the apportionment of blame between the employer and the labour hire company, guys. And importantly, Brendan Tinworth contracted Q Fever whilst working at the Wodonga Abattoir. What's Q Fever, Kath, do you know?
I actually have no idea what Q fever is, Tony.
John, do you know what it is?
It's a very serious and debilitating injury to the worker in this instance. In this case, the Supreme Court...
Let me tell you what it is first.
Tell me, Tony.
Q fever is an airborne bacterial organism carried by cattle, sheep and goats. It's in the air, and it's important that if you're working in the industry, that you've got to be inoculated against Q fever. And if you don't get inoculated, the key to it is that you should be wearing a mask. So
is that the only way to protect yourself?
Generally, that's the way to protect yourself.
Is there any immunisation that you can take against it?
Yes, you get inoculated against it.
Therefore, the duties on the employer to ensure that the workers are all protected from this fever.
Of course. Look, the sad thing about this particular plaintiff was that he was a new employee. Most of the other employees had been inoculated against Q fever, but they ran out of
the inoculation.
Yeah, they a bit like the flu when it hits, and they don't have enough flu injections.
And what did they do?
Well, what they should have done was insist that he wears a mask, and he wasn't wearing a mask, and in that time he contracted Q fever.
Did they provide the mask though, Tony?
Oh yeah, the employer provided masks.
So then is that contributory negligence on behalf of the plaintiff?
That's the issue in this case.
Oh,
this
okay.
case that we're talking about right this minute is not so much what the plaintiff got, it's more a case of who was held to blame between the employer and the labour hire company that provided the workers to the employer.
The claim was actually compromised, Kathy, in the sense that the money side of things, damages to the injured worker, was settled. Now the question between the two defendants, which were the employer and the hire company, was who's
pays?
to blame and what apportionment is there.
So enlighten me, what happened?
All right, let me take it further. Q fever is something that you can contract from animal feces, urine, blood and pregnancy fluids contain large numbers of the bacteria. That's generally how you get your Q fever. Now, he started work in October 2000 and he was in a hanging room, weighing carcasses, applying tickets and moving them through the room. He was a very competent worker. That's how he was described by his employer. And In April 2001, he and other employees attended the pathology to have a skin test to determine whether they had the presence of Q fever. And sadly for him, he tested positive. Other people got inoculations shortly thereafter, but there was no point in inoculating him because he already had the condition.
Too late.
In 2004, he became very, very ill because of the Q fever, and he had to have surgery to have his aortic valve replaced. So he had a very bad heart condition. So based on this, John, you'd think that he would have received quite a bit in damages.
Oh, you think so, for pain and suffering and for economic loss?
What do you reckon he'd get for pain and suffering, John? We don't have the figures, but
Well, the maximum is $480,000. You'd think around 250,000 at least.
I'm not really sure if Q fever kills you or eventually kills you, but
It's a significant condition which has stopped him from working, and my understanding of Q fever is you will never get rid of it.
yeah, well, that's right. It
So
stays
it's
in the system.
life-threatening.
It is.
Well,
That's
you'll
not
have it for the rest of your life.
Well, to take it a bit further, he resumed work at the Abertine in May 2009, undertaking lighting jobs, but his employment was terminated. This coincided with a deterioration in his replacement of the valve, which required further replacement. So it sounds to me that he's going to have a lot of problems in the future.
It does. So hopefully he received enough compensation, at least for medical expenses, if anything.
Well, medical expenses are ongoing, Kathy, so that's not an issue for
That's
him.
right.
Yeah.
Economic loss would be significant here, Tony.
Okay. Well, John, what can you tell us about how the court apportioned the blame?
Well, the Supreme Court sitting in Wodonga, His Honour Justice Jack Forrest decided the matter and found that 60% of the blame should be apportioned to the employer themselves and 40% to the hire company. The employer, Tony, cannot contract out of their responsibilities.
But John, there was a lot of to and fro and debating in this case about what responsibilities they had, because I understand that the labour hire company had quite a bit to do with the management of these employees.
Well, that's correct. However, the employer has the responsibility on the day-to-day management of the worker in their own premises, and the employer is responsible for the safety of the worker in their own premises.
John, employers as a whole, as a rule, have a non-delegable duty to ensure the safety of their workers. Is that a higher test, Kathy?
It's a very good question, Tony. I think that, but look, they can't escape their duty. That's what it comes down to. So the test, it depends on the threshold, I
Anyway,
suppose.
look, we'll
but
discuss this in another episode,
I think
it is a higher test.
But we should also thank the workers that are in the meat industry, because we do appreciate what they do for us in our daily living.
Look, we've got to go to a sponsors break, guys. So let's viewers, please don't go away. Stay tuned. We've got the mailbag just after the break. Thank you.